This is Nick Thompson in Louisville, Kentucky. When we handle student loans, it sometimes comes up, how do I bankrupt my student loans? The only way to really bankrupt your student loans is by filing a separate lawsuit in bankruptcy court called an adversary proceeding. The adversary proceeding is just that. It's a separate lawsuit where you're suing creditors or you're suing someone in order to make sure that the bankruptcy gives you the fresh start that you need. Quite often, we'll have people that have $100, $200, $300,000 in student loan debt, and even if they tried to go out and they attempted to get an affordable repayment plan under an income-based repayment plan, it may be that their student loans are simply not going to leave them with even a minimal standard of living, that they're going to unfortunately be without food, shelter, clothing, medical care, and the essentials that you need to provide yourself and your family to start life over again. And that's the purpose of bankruptcy, is to be able to start life over again, pick yourself up after you've fallen off your horse or fallen down. There is an undue hardship discharge for student loans. There have been 3 different studies that have shown that about 500 to 600 people every year apply for the undue hardship discharge, and about half of them are actually able to bankrupt their student loans. I'm not talking about whether or not the student loan was protected to start with, because some student loans are not protected. It may be that the student loan was not for a qualified school or a qualified course of instruction. So it was just as dischargeable as any credit card debt. What I'm talking about is that even though you were a qualified student, even though it was a qualified school, it was a qualified course of instruction, they didn't give out too terribly much money over the limit of what a student loan should have been, even though they met all the other qualifications, you are partially disabled, or you're in a situation where paying that student loan back would be an undue hardship. And it's such an undue hardship that the judge, because of the equity and the fairness of things, should go ahead and discharge that student loan, even though otherwise it would not be dischargeable. Most attorneys and most lawyers believe that it's impossible to discharge student loans. That's just not true. Quite often, if you're talking to an attorney that thinks that it's impossible, the attorney doesn't want to do the work, there's not enough money involved, or there's other reasons why that attorney is not the attorney to use for your bankruptcy. What's happening is that the attorney doesn't know what the law really is, or there's other problems that that attorney has. And it's quite easy to fall under the myth that you can't discharge these student loans. The truth is, half the time you try it, you're going to win. You're going to either get a partial discharge of your student loans, or you may discharge them altogether. And that's what the studies have shown. There's 3 different studies on my website, one by Lacey and 2 other academic studies that shows that half the time you file an adversary proceeding to get your discharge of these student loans, about half the time you're going to win. And many of the people are not lawyers. They're filing these requests for a discharge. Occasionally you can get a lawyer to do it, okay? But many times the individual filed his own case and he just showed up and he proved it. The common test that's used is called a Bruner test. And the Bruner test basically looks in what your history has been, what your past has been, what your present circumstances are, and what your future circumstances are. Essentially, if you're at the poverty level or you have partial disability that keeps you from having a lot of income, and you are doing, if you were forced to pay the debt, you would be doing without food, shelter, and clothing, or the essentials of life, okay, then you've proven that it has been an undue hardship. It doesn't have to be that you're going to die or something like that, but most people that are on Social Security that have a garnishment for that Social Security, most of these people would qualify for an undue hardship discharge. The three elements of the Bruner test are: first, you cannot maintain, based on current income and expenses, a minimum standard of living for the debtor and your dependents if forced to pay off the student loans. Let me explain that at one time, even though I'm a lawyer in federal court, in 2001, I got this undue hardship discharge. At that time, I was paying about 40% out of my wages and taxes, and I owed child support to two different women. And because of the fact that about 80% of my income was gone, and I was living only about on 20% of it, at that time, when I filed bankruptcy and I was going through a divorce, there was not enough money left over if I had to pay my student loans to pay for food, shelter, and clothing. I filed for the undue hardship discharge, and Judge Lloyd granted it. She was a new judge at that time. The question before Judge Lloyd was, which was more important, paying child support or paying these student loans? Because there wasn't enough money to pay both. Therefore, there would have been an undue hardship discharge violation for the children. It would have taken away food, shelter, and clothing for the children. And at that time, she was going through the divorce, and the United States Attorney was also a female going through a divorce, attempting to collect child support, if I remember correctly. The two other elements of the Bruner test are: additional circumstances exist indicating that for the state of affairs is likely to persist for a significant portion of time going forward as far as the repayment of the student loans. It's a forward-looking test, and basically, is this condition going to continue for a long period of time going forward? Here is where this test becomes helpful for both private and government student loans. If you have a servicer who has been demanding that under the income-based repayment plans for you, that you have to pay a high amount, this will often force that government student loan servicer to give you a lower amount. And even if you're not going to win and you're not going to get a total discharge of all your student loans, some of the student loans may be discharged, or you're going to get a lower payment amount. Because if you can't afford the high payment amount, let's go ahead and lower it. That's what the government's going to come in and say. There's a big difference between government student loans and private student loans that defend these undue hardship discharges. With the government student loans, there's always an income-based repayment plan that you should be able to qualify for. If there's an if the budget and the income-based repayment plan is a burden for you, the government will go back and recalculate this and will often lower the payment so it becomes affordable for you. So you can force the government to the table and come in before a federal judge, and they'll go, well, it's true that it was difficult for them, but we now have recalculated this payment and we're going to make it affordable now. It may provide you the relief that you need. With a private student loan, they have no affordable payment plan. You owe $250,000 to a private student loan, and you're doing without food, shelter, and clothing for you or your children, then there is no income base that they can lower the payment at. You're either in default or you're not. And because of that, quite often the judges will give a full discharge of private loans but they will knock out quite often just part of the student loan, the government student loans, and you may be left with one small loan, but they'll knock out the larger ones, or they may force a temporary low payment amount and have you come back in future years and submit a new budget, and you may be able to turn that into a longer plan. The third part of the Bruner test is that you've made a full good faith effort to try to repay the loan. You've exhausted all the administrative remedies. You've looked at whether or not you could have gotten a disability discharge, whether or not you could have gotten other discharge that are what we call the administrative discharge charges, whereby you went back and you worked for 10 years for a nonprofit. All of all of these things have been exhausted. You've done everything you can. You've applied for the income-based repayment plans, and even though it lowered your payment amount some, it didn't lower it enough for your circumstances. It used to be under the old rules for student loans that you could bankrupt a student loan once it became 7 years old. And that prevented people from just going out and filing bankruptcy the day after they graduated from college and getting rid of their student loans. The judges quite often want you to make a good faith effort to repay the loans, which is why you need to make sure that you have applied for these income-based repayments if it's a government student loan, or that you've at least made every effort that you can to repay this. When you do go into bankruptcy court for an administrative discharge, for an undue hardship discharge, the lenders quite often will look at what your circumstances is. They'll go over your tax returns for the past couple of years and your bank statements for the past couple of years. And if you have been buying other things that you perhaps didn't need instead of paying for your student loans, this will be brought up that you haven't made the good faith efforts to try to repay the loans. But for some people, it doesn't matter what you did or could have done. The burden is so significant when you owe $250,000 in student loans that it may not matter whether or not you made an effort and tried or didn't. It may be that your income was so low that regardless of what you did, sending in a $5 payment was so insignificant that the judge is not going to require you to do a good faith effort because you never had the ability to pay to start with. What I'm trying to say is that make sure that you've gone over all of the elements when you have a student loan, that you've looked at making these student loans affordable. And there are many different things that you can look at when you analyze this, such as whether or not the school was qualified that you went to. We do an analysis in our office of student loans, and we have web pages on our website. And if you have a problem with your student loans, you should review that, because we've tried to write it quite well for you so that you can do an analysis. If you have a government student loan, there's software that we point you to called Student Loanify that will help you get into the program that's best for you. Quite often, the servicer for the government student loans will put you in the program that makes them the most money, because they're a debt collector working for the Department of Education itself. They're not your best buddy, they're not your best friend. They're looking to make as much of a profit off of you that they can make. If you've got these student loan problems and you're thinking about filing bankruptcy, please come into our office. We try to take these programs on, and we do a full analysis of these things with you. This is Nick Thompson in Louisville, Kentucky. Thank you.